Welcome to K-Talk, lesson number 5. I'm Dan O'Gorman, Associate Professor at Barry University School of Law.
And I'm Steve Maxwell, Director of Academic Achievement and Lecturer in Law at the University of Miami School of Law.
And on this episode, we continue our Blackletter series. Lesson number 5 continues contract formation, and we're going to be talking about the acceptance of an offer. As we learned about last time, a contract has 3 elements: offer, acceptance, and consideration. And we are on to element number 2, acceptance. Now, Steve, as you may recall from last time, an offer is a significant event. You can almost say it feels empowering. Can you feel the power, Steve?
I can. I actually get the feeling of a serve in tennis. You know, like the offer feels like a serve.
Oh, I like that. And we will continue with that analogy during the course of this episode. We'll talk about putting the ball in the offeree's court. There's a song, I've Got the Power. That's a song, isn't it?
Oh, yeah. Like the dance thing from the 90s or 80s or something.
Yes. So in other words, you're not sure who sang that. I'm not. I don't know who sang that. I've got the power. But so who's got the power when there's an offer? Well, of course, it is the offeree. So an offer gives the offeree something called, you can either call it the power of acceptance or the power to form a contract. You are granting to the offeree the ability to form a contract. And as we will talk about, the grant of this power means that the ball, keeping that tennis analogy that Steve has brought up, is going to put the ball in the offeree's court to decide whether or not a contract will form. So it does create this power. Okay, elements of an acceptance. So, Steve, you know I love elements.
I love elements too. They help so much. They give it form.
They do. I love breaking things down into its component parts. And so I've taken the definition of offer and I've disaggregated it and put it into elements. And I actually see more than these 4 elements that you will see on the PowerPoint, but we're going to talk about some of these other elements in other episodes. What we're going to talk about today is the requirement that the offeree manifest assent, but we're not done there. You might think, well, that's done, right? The acceptance, offeree manifest assent, we're out of here. Not so fast, Steve. You must also be an offeree. Element number 2, as I like to refer to it, your acceptance must be to the terms of the offer, at least under the common law, if not Article 2 of the UCC. And 4th, your acceptance must be in the manner invited or required by the offer. We're going to go through each of these 4 requirements. Okay, manifestation of assent. Now, as you see here, Steve, I have a list of stuff, a list of things to talk about, because I could say manifestation of assent means that you are assenting to the deal, that a reasonable person would think you're assenting to the deal. But we want to be a lot more detailed about that and talk about some of the issues that tend to arise within that requirement. And notice, you see who's back there in our first bullet point under manifestation of assent. It's an old friend, isn't it?
Oh, it's probably the oldest friend.
It is. It's a very old friend. The objective theory of contract is back. I tell my students the objective theory of contract runs through so many things in contract law, and so they really want to have a firm grasp of what it means. So manifestation of assent, right off the bat, you'll notice that it says manifest. And as we've talked about on prior episodes, manifest you can think of as having 2 components, because I think you talked about this, Steve, or you brought this up, that you like to think of manifest having 2 components, and that made a lot of sense to me. The one is that, of course, it has to be outward, generally intending to do something in your own mind, thinking something in your own mind, tends not to count in contract law. It must be displayed outwardly. And in addition, The objective theory of contracts says that a reasonable person would have to construe that outward manifestation as indicating that you are intending to assent. So just like with an offer, you could accidentally make an offer, not intend to make an offer, but if a reasonable person would believe you were intending to offer, it can be an offer. Same thing with acceptance and manifesting assent to the terms of the offer. You could accidentally accept. You don't intend to accept, but everything you say and do that you outwardly exhibit, our friend, the reasonable person, if they construed that, would construe that as you're assenting to the deal, then it is a manifestation of assent.
And here on the acceptance side, it seems a little more consequential if you accidentally accept, because at that point, you really have a binding contract. If you're an offeror and you accidentally give an offer,
yes,
you have a chance that someone's going to reject it or do something else besides acceptance. But if you're the offeree and you accidentally accept, done.
Whoops. Oops a daisy. You're absolutely, it's true. Because, and let's not forget about revocation. So if you accidentally make an offer, before that power of acceptance is exercised through an acceptance, it really does behoove you to act fast and revoke that offer. Don't sit around and hope that the offeree will not accept. You're absolutely right. And that does go back to this idea that the offeree has a power of acceptance. The offeror, I don't think we call the offeror as having a power. When you think of a power and being able to exercise a power in law, it means that you have the ability to change legal relations. And by making an offer, it is only that first half of manifestation of mutual assent. It's the first half. And so you do have an opportunity to pull it back. Whereas with an acceptance, you don't. Once you accept, as I like to say, the trap is sprung. And this is a pretty important point. I think, at least for law school exams, because these are easy questions to write. It's the old situation, Steve, where you make an offer to me and then I accept. And right after I accept, either you, the offeror, want out, either because you were intending to make a joke, or you just don't want to enter into the deal, you reconsidered that quickly, or the offeree wants out for whatever reason immediately. Once you have that effective acceptance, it is too late, even seconds later. And I'll give you an example. Lucy versus Zemmer. Remember Lucy versus Zemmer, a case in the bar?
That's another old friend.
It's a chestnut, Steve. We call it chestnut. That's right. Another old friend. So yeah, I get to replay Lucy v. Zemmer every year, and I'm happy to do it. So in Lucy v. Zemmer, which probably everybody listening or watching this video knows about, we got our two guys in the bar, and one of them sort of accidentally sells his farm, the Ferguson farm, and the buyer buys the farm. Get it? Buys the farm.
Students don't know what that means anymore. I tried that. And for those of you listening or watching, buying the farm means that the buyer died.
And what kind of world is it, Steve, when a good joke about death just goes over people's heads? It's a worse world, isn't it?
It is, but I guess we could just deadpan it a little easier.
That's right. It's deadpan humor. So in Lucy v. Zemmer, Zemmer claims he is joking around about selling the farm to Lucy. Lucy alleges he is taking Zemmer seriously, and the court ends up holding that Lucy's belief is reasonable, and therefore a deal has been reached. Well, as you may remember, Zemmer claims, this was Zemmer's testimony, Zemmer alleged that the minute he realized Lucy was taking him seriously by placing $5 on the table, which was just seconds after this deal had allegedly been concluded, Zemmer says, Hell no, I was just joking. What are you taking me seriously? That's liquor talking. So seconds after this deal was apparently concluded, Zemmer, according to Zemmer's testimony, tells Lucy, I'm just kidding. And a great question is, does that matter? Because at that point in time, Lucy's not gone out and acted in detrimental reliance. He hasn't gone out and tried to get financing or spent money figuring out if the title is satisfactory, any of that stuff. And it doesn't matter. And that's pretty harsh. But that point in time of contract formation is quite significant because we use the phrase, the trap is sprung for a reason. It is a trap. If you could get out of it seconds later, it wouldn't be called a trap. So yes, very good point, Steve, that you accidentally accept. I'm sorry, you have to think of another way out of that trap, but you're not going to be able to argue lack of contract formation. So some of the things that I like to teach when we're talking about a manifestation of assent are things like the duty to read rule. I'm trying to find a home for the so-called duty to read rule, and I tuck it underneath the manifestation of assent because it seems to me that that's where it belongs. This is this idea that even if you did not read the contract, so it's a written offer, you didn't read it or you didn't understand it, this almost never is an excuse or an argument that a contract did not form. Now, note, there's going to be two different things going on here. One is, does the duty to read rule mean that a contract still forms, even though you didn't read or understand the writing? Another one is, does that mean also that all the terms in that writing are binding? Slightly different issues, but basically the same. And the answer is going to be the same for both of these. You are expected to read your contract. If you don't, that is on you. And you have manifested assent to this deal, even if you weren't reading, even if you didn't read it, even if the other side knew you didn't read it, and it doesn't matter. A contract is still going to form. And it's going to, you know how harsh this is, Steve? So let's say I'm blind. And so I sign this contract and I don't read it. I can't, I'm blind. What do you think? You think am I stuck under the duty to read rule?
It sounds like you probably are.
Because it's unforgiving. You are. So the duty to read rule is really nasty. The duty to read rule said, the duty to read rule is very old school, sort of, you got to look out for yourself. So what do you think? The duty to read rule is going to look at me when I say, hey, I'm blind. I didn't read the contract because I'm blind. So no contract formed. What do you think the duty to read rule's response is going to be to me? What does the duty to read rule think I should have done?
Yeah, I think the duty of to read rule really is just, I don't know what it's saying, but I do know what the court, it seems like the court, this is a rule of expediency. This is making it easy to decide, what's going on, because it puts on the offeree the onus to not accept until they have read. And if they choose not to do that, it doesn't rescue them from that mistake.
Yeah, exactly right. So, the duty to read rule is going to have expected me to have somebody read it to me. Go find someone to read it. I am assuming the risk of what's in that contract. I know I'm blind. I know I haven't read it. I should have gotten somebody to read it. And I do like how you've brought up this idea of expediency, because I think that is a lot of what's going on. Think about if we didn't have a duty to read rule and parties could come in and claim, I shouldn't be bound by this contract. That shouldn't be a manifestation of assent because I didn't read the contract. It would cause all sorts of problems, particularly for businesses that use form contracts. They now have to sit there and read the contract to everybody. And it would really, I think, undermine the ability to rely upon contracts. And so for expediency purposes, the court is going to say you are stuck. Doesn't matter if you're not fluent in the language. You find somebody who is fluent in the language. The only little exception, which we really don't need to spend too much time on, is when the other side makes a misrepresentation about the essential nature of the contract, and you don't have a reasonable chance to learn what the terms actually are. That's very unusual that you wouldn't have that chance. I think really the only one we see is exception to formation is when the reasonable person wouldn't even understand the document was contractual in nature. For example, you go into a you go into a building and you drop your coat off at the coat check place and you are handed a ticket for your coat. And I think this is probably more of a northern thing. So I went to school up in the north, and so I remember coat checks in the north because I think everyone's cold and they've got their coats, and you go into a place and you want to shed your coats. Down here in Florida, I don't see that many coat check. Like you were in
no, never. I mean, there's like one day of the year where you break out the coat.
right. And that, of course, or a jacket, that would, of course, be K-Talk podcast. But so like, let's say you go to a coat check place, you drop your coat off and you get a little ticket. A reasonable person is going to assume that that ticket is nothing more than an identification of which coat is yours. And if on the back of that ticket is some language, let's say, that says that there's no liability for the company losing the coat or something like that, you had no reason to believe that that little ticket was contractual in nature. So that's really the only exception. If there's a document and you have no reason to believe it's even contractual in nature, then you wouldn't have a duty to read, because why would you read that? You have no reason to believe it's contractual. But general rule, it's a contract you're signing. You have reason to know it's a contract you're signing. You are responsible for figuring out what the terms are. And note that the word duty here. So this is going to be for those students where your professor might be sort of a real kind of, maybe I would say stickler is not the right word, but really honing in on terminology. And note that duty here, there's not really a duty to read. In law, when we think of a duty, we think of somebody else has a right. And if I breach my duty, the party that has the corresponding right can sue me for breaching my duty. Well, if you don't read a contract and you don't really breach a duty to read in a certain sense, no one's getting sued simply because they didn't read the contract. Can you imagine that? I don't read a contract. There's no problem. I'm not trying to get out of this contract. Can you imagine the car dealership suing me saying you breached a duty to read? You should have read that contract. It's ridiculous.
I think we'd all be guilty if that were true.
The courts would be flooded. I mean, you could start. I mean, I would go back into practice and just sue. Hopefully, there's an attorney's fee provision. I would just sue for breaches of the duty to read. I mean, we'd be doing great.
That would be a great little side gig, right? Just go suing every car buyer for not having read.
You didn't read, yeah. And then I'm getting sued too. Everyone's suing everybody.
Yeah. Well, this duty to read rule, that's not really a duty, seems to just be going ahead and proactively taking away the defense that I didn't read this.
That's exactly right. It means nothing more. And when I say this, I don't mean it's not significant, but it means nothing more than that those terms are binding against you. So yes, you cannot raise as some sort of defense or excuse to avoid that contract that you didn't read it. That's all it means. And that's a lot, but it doesn't mean more than that. Okay, knowledge of the offer. So as a general matter, an offeree will not be held to have manifested assent to an offer unless they have knowledge of the offer. Now, as you may recall, and I can't remember for sure if we talked about this, but an offer doesn't become effective until it is received by the offeree. So an offer, say in transit, which I know is more old school with snail mail, but an offer that is in transit is not yet an effective offer. It's got to be received. Once it is received, of course, then we know that the offeree has the power of acceptance. But if the offeree is not aware of the offer, the general rule is that they cannot accept that offer. It wouldn't be an effective manifestation of assent. Now, we know this is true for the following type of contract, what is called an offer for a unilateral contract, something we will talk more about later in this episode. An offer for a unilateral contract is when the offeror seeks performance as the method of acceptance, not a return promise as the method of acceptance. Classic example, reward offer. Patches, a cat has gone missing. Patches, my cat. I post flyers around the neighborhood offering $500 for a return of Patches the cat. Steve, I don't want you to promise to find Patches the cat. Well, why would I want to promise from you? I mean, I guess, but not really.
I was planning on running up to you and saying, I accept.
And that is not going to work. But, I had a very, very smart student once say this following to me, because I had said in class, I had said, well, that acceptance, if that's an offer for a unilateral contract, which reward offers almost always are, then we know the only way you, Steve, can accept is by performing a return promise, which would be saying I accept is basically promising to do it, essentially. That is not an acceptance. So I had a person run up and say, I promised to find Patches the cat. And I had said, that's legally, that's nothing. That's nothing. And the student, very nice student, I think came up to me after class. Professors always appreciate that. If you're going to point out that you think the professor is wrong, after class is always a nice time to do rather than right in the middle of class. Comes down and says, Professor, I'm not so sure I agree with that. I'm like, okay, why? He said, I think it is a counter offer. I think it is an offer for a bilateral by the person who is saying, I promise. Could you say, so when you say I accept, Steve, could I go, no, I accept your acceptance.
That seems like two acceptances passing in the night.
Yes. Yeah.
I don't get it.
Yeah, it's not worth worrying about. I think it was a very interesting point by the student. But so if it is an offer for a unilateral contract, sadly for the offeree, if the offeree does not know of the offer at the time of completing performance. So the good news for the offeree is if the offeree learns of the reward offer or the offer for unilateral contract at any point prior to them completing performance, and then they do complete performance, then they are entitled. That's a manifestation of Ascent. They are entitled to the promised performance. But if they perform fully and then learn, they are out of luck. So wait, Steve, could this be true though? This sounds horrible. So is what I'm saying is that the person who finds Patches the cat because there's a reward offer and only finds Patches the cat because he or she wants compensation, gets a recovery in contract law. And the Good Samaritan who returned Patches the cat out of the love of Patches and or the offeror gets no recovery?
I'm reminded of a wise person who once said, there's no crying in contracts.
And that person would be Steve Maxwell.
And this is a situation where your prof can give you a real tearjerker because it doesn't seem fair. It really doesn't. And as you're mentioning this about, the Good Samaritan or the person who finds out about it, not to jump too far ahead, but the way I see it, the only way that the offeree's conduct could have been influenced by the offer is by knowledge of the offer. And so this could just be the law's recognition that if you didn't know about it, then you're no worse off for not being compensated.
And if you think of it, it actually sort of makes sense. So I have two thoughts on that, and I agree with, and it's going to follow up with what you just said. The first one is, hey, we're contract law. We're not anti-Good Samaritans, but that's not what we do here. So contract law is about making contracts, and you talked about influencing behavior. And that's what we do with contract law. We want to encourage people to enter into deals and to be confident that those deals will be enforced and therefore rely on them. Rely through making deals with third parties, rely through starting to perform, through preparing to perform. We love that stuff. We want to make people confident in that. And contract law is we're not in the rewarding Good Samaritan business. I don't think that means that contract law. And I know I talk about contract. I do it, I what anthropomorphize it. Did I say that right? I think I messed that right. I know I talk about it like it's a person, but I don't think contract law is not really so much concern. That's not their business as Good Samaritans. You want to reward Good Samaritans? Well, why pass a statute? What does contract law care? But that's not what contract law does. And so the Good Samaritan doesn't need, and this is basically following up on that point, which is that in some respects, the Good Samaritan doesn't need that extra nudge. So if that reward offer, if you think about it, that reward offer is in part maybe, like, let's say everybody knows that Patches has gone missing and no one's returning Patches. And so now you put up a reward. Well, why are you putting up that reward? Because you felt like the people in your neighborhood needed some incentive to do it. The Good Samaritans don't need that incentive. Contract law comes in there to provide the incentive for people to do something for you that they otherwise wouldn't. So the Good Samaritan doesn't need the reward. The Good Samaritan is going to do it anyway. So much for a Good Samaritan. Now, offers of a bilateral contract. Oh boy. So my guess is most bar prep material will say an offeree cannot accept an offer without knowing of it, and does not make a distinction between an offer for a unilateral contract and a bilateral contract. Is that your sense? Without you, I know, Steve, you don't know all bar prep material, and it's a pretty narrow question, but is that probably right that we see that?
It does, or they're asking you a direct question on that particular rule of law, but it's not something that is a huge ticket item. Sure.
Right. And so I think, bar prep companies are saying you can't accept an offer without knowing of it, and they're not distinguishing between offers for bilateral and offers for unilateral. That seems to me to be probably a decent test taking strategy. And, because you can only know so much stuff. But here's the deal. The reality is you can accept an offer for a bilateral contract, even though you didn't know the offer was made. And I'm going to give you two examples, one of which is fanciful and the other real. So the first example was one by a famous contracts professor from Fordham, Joe Perillo, a legend in contracts law. Joe Perillo had this hypo where, Steve, I send you an offer in the mail and you receive it, but you don't open it and you don't know what's in there. You have no idea what's in there. You're like, oh, you probably think it's something to do with K-Talk or something, right?
Right.
But you don't know it's an offer. And you decide to play a joke on me. So what you do is you write back to me and you say, I accept. Now, note, you're doing this even though you have no idea what was in that envelope. You don't even think it's an offer necessarily. You're just trying to be a funny guy and you say, received your letter, I accept, you send it back. You would have a contract because you've I, as the offeror, have reason to believe, as the right objective theory of contract, that you are manifesting assent. And the fact that, you didn't know of my offer, well, you shouldn't play around with I accept. So it is possible, though it's extremely unusual this would ever happen. But now let me give you an example where it can happen and did maybe happen in the real world. I am an employer. You are a prospective employee and we are negotiating. And I send you a written employment contract. It is signed by me and I send it to you. We've already had preliminary negotiations. We feel like we're just about there. So I send that out to you. You receive it. You do open it, Steve. You do read it. You sign it, but you change a term. You change the severance policy, enabling you to either get more severance or to get severance even if you're terminated further down the road than I wanted you to get severance, and you send it back. Now, as we will learn, this is not an acceptance because you've changed the terms of the deal and it's not Article 2. So that's a counter offer. I receive this thing and I just look and see that you signed it. I do not notice that in the middle on, say, page 3 of 5, you've made a change. So I have no idea that you have, in fact, made a counteroffer, and I file it away in my filing cabinet. And then you show up to work a week later, and I let you start work. Well, the court could, if it was reasonable for me to have known you made a counteroffer, I accepted your counteroffer by allowing you to come to work without any objection. You made the last offer. That was your counteroffer. You show up. Last offer on the table was yours. I let you work. If I had reason to know you'd made a counteroffer, I am bound, even though I didn't know that there actually was a counteroffer. So it is possible, but it is very unusual. So probably the smart strategy is just to say, okay, if you don't know the offer, there's not going to be an acceptance.
And that just seems a little bit weird, because isn't there a duty to read? Like if they didn't look and see that change was made, isn't there a duty to read? How this just feels inconsistent to me.
Yes. So you have so I think you have a duty to read unless there are special circumstances that would excuse you. Now, I know what you're saying is like, thanks for nothing. What are special circumstances? And I think so that was an issue unresolved. This case went to the First Circuit, and I think it went back down for jury trial on whether it would have been reasonable to know that there had been a change. This is the way I look at it. Remember how we talked about that you have to have reason to know something is contractual in nature. So in other words, the duty to read rule isn't meant to be a game of gotcha. What I often do, I don't know if I did this, I probably didn't do this with your class when I taught you contracts, is, I'll pass out the attendance sheet and it gets passed around, and right on the back of it, by signing this attendance sheet, you promise to pay for us, Cyril Gorman, $100, or you promise to wash my car for $2, something hilarious. And then the question is, at the end of the class, I hold it up, is, are you bound? And the students should recognize that there was no duty to read the back of the attendance sheet because they had no reason to know there were contractual terms there. So it seems to me, in a case like the, unknown counteroffer, because the form contract has been changed, the question would be, you only have a duty to read if you have reason to know that it is contractual in nature. Now, obviously, they understand this is contractual nature. They wrote the contract, the employer. But it seems to me the question on that unusual situation is, you only, I assume, would have a duty to read if you have reason to know that there were changes. So, again, it's not supposed to be a game of gotcha. Aha, I made this little change and you didn't notice. Gotcha. And so one of the problems the court noted was that I don't think there had been a cover letter included saying, by the way, I've made this change. Like, I want to think some bar rules actually require lawyers that if you make changes, you're supposed to alert. You're not supposed to just take like a contract that the other side gives to you, make changes, sign it, and send it back and never say anything. It's almost like you're suggesting that there haven't been any changes. So I think the duty to read, I'm not sure we know if the duty to read kicks in that situation. Again, if I recall correctly, the First Circuit said it's up to the jury to decide whether or not it would have been reasonable to have reread that thing before. Now, I mean, I think, it would get a little more interesting if they had, I think if they said, I made changes, now you're in trouble. Please review, I've made changes. Well, you better read it now. But I think when they don't say anything at all, it gets a little bit closer. So, but in general, I would assume, you should assume probably, offer doesn't have knowledge of the offer. The vast majority of time, that's not going to be an acceptance. Okay. Grumbling acceptance. I know you like this one, Steve.
This is my favorite.
It's a great name, the grumbling acceptance. So the grumbling acceptance is, of course, an acceptance. I was tempted to say it's an acceptance because it has the word acceptance in there, but that won't work with things like past consideration, right? Or the duty to read rule. You can't believe everything you read. So a grumbling acceptance And yes, Steve, we are going to talk about flounder.
Oh, yes. Favorite.
How could we not? So a grumbling, which I just talked about in class, grumbling acceptance is when the offeree manifests assent to the deal, but they complain about it. I like to think kind of like, the grumpy old man, who's like, this offer stinks. This is highway robbery. I have no choice, but fine, I'll take it, and accepts it. That is, as long as you are manifesting assent, the fact that the offeree at the same time expresses displeasure, even extreme displeasure at the terms of the offer, does not negate the effectiveness of that manifestation of assent. Now, so the dividing line here really is between a grumbling acceptance, which of course is an acceptance, and then say a rejection. And there is this wonderful case that Steve knows well, a case where a guy is presented with an amendment to his employment agreement. And he voices extreme displeasure at this amendment, telling the employer that this means you could fire me at any time, and just really goes off on about how unfair this is. He doesn't like it. And then what he does, but he doesn't go, but I guess I got no choice. He doesn't do that. He doesn't say that. He expresses all this displeasure. And then he writes as a signature, flounder. And no, his name is not Flounder. That is not his nickname. We don't know why he wrote Flounder. A student suggested to me years ago that it may have been a reference to Animal House.
Yes, and I just saw that for the first time about 2 months ago. And that's exactly when I was watching Animal House. I thought, flounder, no way, this is that case.
That's the best ever. That is the leading theory.
Yeah, because the character in that film was not popular. He was kind of like he was the one that didn't really fit in. And so I wonder if you're signing flounder, you're identifying, I don't really fit in here.
Well, very interesting. So yeah, you're going deeper with this than I had. I was just happy to have some sort of idea why in the world this would be flounder. I mean, it's like, did he sign it herring last year and bass the year before? Is this a thing? So this case, so here's my thoughts on this case. It's amazing. It's not simply amazing because the guy signs it flounder. So that gets it a long way toward amazing. It is the fact that almost invariably, students will have a yes or feel quite confident yes or no on the answer to whether his signing flounder was a manifestation of assent. And it usually goes one of two ways. They either say, well, he signed it. Yeah, he put flounder, but he signed it. He's stuck. He signed it. It's like X, he's stuck. Or they say, well, is flounder his name? And I said, no, it's not his name. Is it his nickname? No, it's not his nickname. Well, it's not binding because that's not his name. So there's very black and white, but interestingly enough, black and white on different sides of the fence. And what students don't appreciate, and this is why the flounder case is such a wonderful case for new law students, is that whether or not flounder is a manifestation of assent, like interpreting language generally, and actions plus words, depends not only on the text, so to speak, the actual words used, but also depends upon the context in which those words were used. So when he writes flounder, you've got to consider what came just before that he was voicing, that he was grumbling. Grumbling isn't irrelevant. I mean, it's irrelevant if what comes after that is acceptance, but if what comes after that is unclear, the grumbling nature of it that surrounds it is relevant to giving meaning to the words used. And the court said that a reasonable person, based upon his extreme displeasure that he had voiced, plus flounder, a reasonable person would view it basically as an act of defiance, not as an acceptance. If he had said, oh yeah, no worries, I'm fine with this deal, And then he laughed and wrote flounder. Now flounder probably is an acceptance. Who knows why he's writing flounder, but that really shows students need to, in law school, and particularly in contracts, move away from this idea that things are always as simple as, well, he signed it or he didn't sign it. It's a yes or it's a no. It's his name or it's not his name. Tell me about the context.
Yeah, I think that's a good hint if you're listening or watching and you find yourself finding a lot of clarity with a fact pattern. I think there's I would just start to be very skeptical of my own clarity and begin to dig a little deeper.
Yeah, I love it. You should be skeptical of your own clarity. If you see,
I think because like you've said it before on a previous episode, where the people who get the top grades are the people who thought the test was hard.
Right.
They saw the gray, they saw the breadth of opportunity to argue both sides, and those that see the clarity are like, we got to cut the blue wire. It's always the blue wire. Let's clearly cut the blue wire, and they ignore the red wire completely.
Indeed. And this reminds me of another case I talk about, which I think you probably remember. Dope.
Oh, I don't know dope.
Oh, maybe I started teaching dope. Okay, so Monster Energy wants to use a remix of a Beastie Boys song. And I know you love this because you're a product of the 80s, right? Beastie Boys, very, very 80s.
Yeah, we fought for our right to party for sure.
Exactly right. And so Monster Energy goes to the guy who did the remix, a DJ by the name of Z Trip, and sends the video. They've done this promotional video with the remix being used, and ask basically, hang on, let me get, I want to make sure that I've got roughly the right language to this, because it's kind of important what they are asked. So hold on just a second. I'm flipping around. There is flounder. I think they ask basically if he is okay with it. Something in the sense of, is he okay with it? And he responds with dope with an exclamation point. And that's all he says. He just says dope with an exclamation point. And the question is whether or not that is an acceptance or not. So here's Monster Energy alleged that Z-Chip had accepted their offer when he wrote dope in an email responding to a Monster Energy email attaching the promotional video and asking him to review it and let it know if he approved. So as I tell my students, oftentimes the most important context evidence in giving meaning to language is what was it in response to? What was asked before that? So he says dope. So what do you think? What do you think, Steve? So dope. That's all he says. Dope. Exclamation.
Dope. I mean, without looking at Urban Dictionary, that sounds like a euphemism for that's pretty cool.
Exactly right. That's exactly what the court said. He said it was too equivocal that a reasonable person could easily have construed that as him simply saying the video was cool, approving to the quality of the video, not giving approval to use it. And so that was not an acceptance.
Even and I want to ask, because that language about asking, like, what can you say it again? What they were asking, what they asked him, that language?
Well, I am summarizing it here. I'm reading my book, so I don't know. I surely don't have it verbatim, but something to the effect of they attached it and asked him to review it and let it know if he approved. So it sounds like Monster Energy was not specific about what they were seeking approval for. Just, do you approve? Okay,
just like, check out what we did here. Do you like it?
Could be. It's certainly reasonable to believe that that's the way what he was inferring from what they were saying. So I think, it would have been a more interesting case, wouldn't it, if they had said something like, would you please grant us approval legal approval to use this.
Yeah,
But then it's
absolutely.
like dope sound, but then it's kind of weird that he would say dope. I mean, that's kind of a strange thing to respond to. Do you approve of, do you give us legal approval to use this? Dope. I think
Yeah. You know what you're doing, like, and I want to, anybody listening, like, needs to think about this as they read these cases. Like, the thought occurs to me that, my goodness, a new law student is just law, law, law. I got to get the law. I got to get the law. I got to get the law. They're not reading carefully the language used by the parties. And if there's a subject first year where that specific language is incredibly important, it's contracts. Dealing with this offer and acceptance, and like just what you did there, they can do that too. What if it wasn't Monster Energy drink and this person? What if it was this party and that party? And play around with it. I encourage the listeners to do that, because it sort of takes us to the next level. If you come to class prepared for, does the role of the parties and the education, all that matter? Like, just play with the material a little bit, engage it. But that's kind of what you're doing. And I just want to be explicit in that methodology.
And this is something that students shouldn't be intimidated by, because their layperson self is ready to do this. So we talk about a lot of times how when you come to law school, a lot of your transition is shedding your layperson self and thinking like a lawyer. But when we talk about interpreting language, how would a reasonable person interpret that? There's no real legal training for that. You get used to doing it, and you get used to grabbing facts. And I've done it for a long time now, so I'm used to doing it. But there's nothing about legal training, it seems to me, that would preclude a new law student from right at the beginning making arguments. I mean, do you really need any sort of legal training to make an argument as to how a reasonable person would what they would infer from the response dope in this case? I mean, I could go to the mall and I could say, okay, say Monster Energy said this and Z-Trip said that. What would you think Z-Trip was saying, assenting to? And they will tell you, oh, he's probably just saying it's a good video. So you don't need to know anything about the law other than the test is how a reasonable person would construe it. But after that, I try to tell the students is, you guys are as good as, what am I? Like, you think I'm a law professor because I'm like it's like a reasonable person test? Like, I'm the reasonable person because I'm a law. I have no, as a matter of fact, I think the longer I do this, Steve, I become less and less the reasonable person.
I think I'm feeling it too.
Are you feeling it? I'm becoming way more technical and narrow about things. That in one respect, the more you do this, and the further you distance yourself from your layperson self, in some respects, you're starting to lose that attachment to the reasonable person standard, perhaps. And so,
yeah, it's kind of like you, and this is a good time. I'm so glad you said this. This is like the moral of the story is don't lose your common sense, because you start to get a little bit law in your head and you start to just completely forget the actual world, and you're obsessed with the words of the legal standard, but you're not thinking about it like you did before you got to law school, which was like probably a more reasonable person at that time.
That's a lot. That is a lot of my class sessions are really just making, like at this point in the semester, making arguments about what would the reasonable person think. And anybody can do that. You don't need any legal training to do that. I'll give you another one, Steve, which you brought up in a prior episode, which is very important with respect to the objective theory and manifesting assent. And that is Embry versus Mckittrick. Remember, where our employee is under a year contract. It has expired and he is working there without a contract. And there's a short window for him to get another job if he wants one. And so he's very nervous. He goes down and confronts his boss and says, if you do not extend my contract right now, I am quitting immediately. And the boss says, don't let that worry you. You're all right. Get back to work. And the question, and he does, and you can see this coming a couple months later, he's fired. And he sues saying that Mckittrick, my boss, accepted my offer to renew my employment contract for a year. And Mckittrick's like, I what? And Embry's like, yeah. Remember that meeting where you said, don't let that worry you. You're all right. Go back to work. That wasn't an accept. I didn't intend that to be an acceptance. And the doesn't matter what he intended. The question is, did Embry believe it was an acceptance, and was it reasonable for Embry to construe it as an acceptance? And this case, Embry versus Mckittrick, perhaps better than any, and it shows the importance of asking what was the question that came before in giving meaning to the response. And a very important point for the court was that Embry had said, if I don't get a renewal now, I'm quitting right now. And that therefore a reasonable person would interpret, don't let that worry you, you're all right, as indicating I'm extending it, because he wanted confirmation that it was being extended for a year. And so a reasonable person could have and would have concluded that that was an acceptance. I think the jury held it was, and the appellate court, if I recall correctly, said, yeah, it was reasonable to construe it that way. All right, on to silence and inaction. Steve, can you imagine a world in which silence was, the general rule was silence and inaction is an acceptance?
That is, that would cause a lot of irrational behavior, I think.
A new industry would arise. I think if you think you're flooded with offers now, think about all the offers.
Oh God, checking the mailbox would be terrible.
It would be like the owls in Harry Potter, right? They're just flying letters flying in. No school ever did that to me. Did any school, do you ever get like the owls in Harry Potter with all 1,000?
Oh my God. Well, spam emails is what they do.
Right?
Yes, you submit that email like you're interested in going to this school, and boom, you're done.
Could you imagine that if silence and inaction was acceptance, the spam email offers, you would spend all your days just rejecting offers. So fortunately, I think both because it's not reasonable to believe that when a person doesn't respond, that they're assenting, it's not reasonable to infer that. Plus the policy reason that we don't want to encourage people to make a lot of offers and then force the recipients, the offerees, to have to reject. They should be able just simply to ignore it and without being bound by a contract. So our general rule is that silence and inaction is not an acceptance. It can be, but it is exceptional. So it is very unusual. And it is in 3 situations and 3 situations only. The first one is when the offeree accepts services being provided by the offeror with reason to know that the offeror wanted to charge for those services and the offeree had an opportunity to reject them. So for example,
is that the example from a previous episode about jumping in the cab?
Well, I guess I would say, so if I jump in the cab, I am probably the offeror because I'm jumping in. The cab speeds away. So I guess in that situation, I would think that the cab driver is in fact accepting by starting performance. So maybe I see some action on behalf of the cab driver. If let's try to make it's going to be, might not be easy, but I think it can be entertaining. Let's try to make the rider the offeree. So I sit down on something and I don't realize it's like, it's a carriage or something. I don't know, about an amusement park, right? I'm like, oh, I need a break. Ooh, it's hot. And let me sit down here. And next thing you know, an engine starts. And then you discover, should you jump from a moving train? I know you're not supposed to jump onto a moving train, particularly with fireworks. I learned that in torts.
Yeah, that's right. I read that somewhere too.
So I don't know if you should jump off. Is that a reasonable opportunity to jump off? But let's say you jump on to something and you're just taking a break. And all of a sudden it starts up and it says, we will be departing in 5 minutes on the whatever tour, and you have reason to know that they would be charging for this. And you just sit there and off it goes. Without question, you are accepting a benefit. You have reason to understand that they charge for it, and you had an opportunity to reject them. That's why I did we'll leave in 5 minutes, so you safely can depart, and you would accept. And this makes a lot of sense if you think about it, because the offeree should not be able to sit idly by, laughing and smirking as this person is providing a benefit, and accept the benefit, could have rejected it, and then doesn't have to pay. So that is an example of accepting by silence and inaction. This raises a host of issues, which students love. Questions such as, when is it reasonable to understand that the person would be charging for this? And the reason why this gets a little complicated is because with quasi contract, there generally has to be a person typically has to be a professional, so the doctor provides the aid to the unconscious person. But we see cases in which it is reasonable to believe that the person is expecting compensation, even though they're not a professional. There's a famous case called Day versus Cayton out of Massachusetts, an old case where a party wall was built. And the neighbor watches his neighbor build a party wall, partly on the other guy's property, partly on his own property. And he accepts the benefit of it because he's now got a party wall, half on his property. And the court said it was reasonable to believe that the neighbor who built the wall was expecting compensation for this. And I don't think he was a builder. So it can be a little tricky. But I think if you see that somebody is doing a lot of work, it's laborious, it doesn't look like they would be doing this as a gift, I think the fact that they're not a professional is not going to automatically mean that you shouldn't have expected that they would want compensation for this.
This is kind of that recurring theme of contract law is not a gotcha situation. This is not a surprise. You should have known that this was happening.
Indeed. And I want to talk about this for a second, because the only thing that bothers me slightly about this is the gotcha issue. Now, you talked about the gotcha issue quite correctly in terms of the offeree shouldn't be able to play a game of gotcha. I knew that he was expecting, or I should have known he was expecting compensation. I sit by and do nothing, and now I don't have to pay, ha, ha, ha. Well, the reverse is interesting. We talk about quasi contract in terms of, generally, if you want a contract with somebody, you are expected to make an offer to them and make it clear you're charging. If you could have negotiated for a contract, in quasi contract anyway, you're going to have to explain, to get a recovery in quasi contract for unjust enrichment, you're going to have to explain, I have a good reason why you didn't enter into an actual contract. And typically it goes as, well, the recipient of my services was unconscious, and I was a doctor. I had no opportunity to contract, or maybe I provided the benefit by mistake. I thought I was providing it. I thought I was mowing the lawn for the guy who had contracted with me. That's why I didn't contract with him. Okay, all makes sense. What's interesting is that in these implied, in fact, contracts with signs of acceptance. So I should pull up to your yard, and you're the right guy. I'm intending to make you an offer, but I don't speak to you directly. And look, this happens all the time, right? Think about what people in New York and Manhattan who squeegee your windows, or maybe, what the characters that come up and get a picture and then they ask for money, or they hand a rose, or what, you're in Paris and they give, do you want a rose for your girlfriend? You give the rose and they hold out their money. What bothers me is that can somebody take advantage of this doctrine? And if they just scoot across the reasonable expectation line, not actually make it clear they're expecting compensation, hoping that the court will infer that it was reasonable for the offeree to believe they were expecting compensation, then never ask for compensation, and then hold out their hand and come back and sue you under this rule. So it's interesting that you mentioned the gotcha, because it's like we got gotchas going both ways. So I'd like to be a little bit concerned about the gotcha from the provider of the bet. Like, why didn't you make it clear? If you're going to squeegee my window, you should ask me, do I want my window washed? And you should not just ask me if I want my window washed, Do you want your window washed? I'm charging you. I mean, how many, has this happened to you, Steve, where somebody asks if you want something in a store, whatever? I used to be embarrassed to do this. Not anymore. As you get older, you get less embarrassed about stuff. I say, does it cost? I'm not afraid to be like, I feel like I'm doing the right thing, asking, are you charging? How many times have you wondered if somebody like refills, have you wondered if they're charging?
Yeah, you know what? I feel that same tendency coming. I want to know because it just, that's, I'm very cost conscious, but that's just my personality. Yeah, I think the only people who would go to that length to do that, I think, are contracts professors.
That's right. Evil. Oh, on exams.
Yeah.
I thought you meant in the real world. Evil contracts professors. I'm using my contract law for evil. I'm like Dr. Evil. So I think that's right. I probably, but yeah, but wait a second. What about, I mean, these people, I've been told, right, that in cities, you go to Times Square, aren't there these characters? People come up dressed as characters, ask if you want a picture taken with them. You get your picture taken, and then it's like a bill is handed to you. Do you remember the movie? It was one of the John Cusack movies. Remember John Cusack?
Oh, yeah.
Yeah. So that's 80s. And it was one of those like Better Off Dad or One Crazy Summer. He's invited over to his friend's house. The friend's mom makes them all dinner. And at the end of the meal, she hands out bills. All of them. So it does happen, right? I think it does happen at times, right? I mean, in Paris, don't they, hand people, you want a flower for the lady, and you hand the flower and they hold their hand out. Now, I don't know if they're suing you, but I don't know, are they going to call the police if you don't pay? So I think it's not just contracts professors that are doing this on exams. I think this does happen at times. They're kind of trying to trick you into entering into a contract.
Yeah, what's that word from, I think it was our first episode where we talked about officious,
Yes, officious intermeddler.
Yeah, that's what this is reminding me of.
It is. I think that, if I was a judge and you could have made it clear and there was any sort of ambiguity, I would be very reluctant to say, now this is just me talking, very reluctant to say that there should be a recovery. I would think that's be pretty clear. If it was a close call, I think I'd be like, next time, buddy, you need to make it clear. You're the offeror. Mm-hmm. You easily could have corrected. You knew you wanted money. Right. The offeree may not have realized.
I think a lawyer would probably make that argument that if you go the other way, you're encouraging this ambiguity, where if, this is a policy reason because we need to have some sort of clarity here, and it doesn't make any sense to enforce something that vague.
Indeed, which is the whole reason why silence in an action is unusual. The second exception that we are told by the restatement of contracts is one I think that doesn't come up much. The second exception is when the offeror tells the offeree that it will construe silence in an action as an acceptance, which of course, it can't just stop there, because if it stopped there, then everyone's going to do that. But then in addition to that, it can be proven that the offeree, in fact, i.e. subjectively intended that their silence in an action was an acceptance. They intended to accept by remaining silent and inactive. I think this is probably an unusual exception, not only exceptions unusual in and of themselves. I think this is unusual because I think it's going to be hard to prove, perhaps, that the person in remaining silent and inactive intended to accept. But if it can be done, then that is also an exception. The third one, which is going to be more common than the second one, is when it would be, and Steve, you're gonna love how helpful this is, when it would be reasonable in these circumstances to construe the silence and an action as an acceptance. Thanks for nothing, right?
Yeah, it's helpful in terms of writing. If you ever see this arguable, that means you can look anywhere in the fact pattern for anything relevant.
You could, keeping in mind, of course, that this is unusual to have any of these exceptions. The good news is, though, we do have sort of the classic example of when it would be reasonable in the circumstances to construe silence in an action as an acceptance. And that is when the parties have prior dealings. They have a history with one another. And as a result of that history and those past dealings, it would have been reasonable for the offeror to expect the offeree to have spoken up if they did not want to accept. So if I have sent you goods for the past 5 years, or I've sent you purchase orders, I'm the buyer, Steve, you're the seller, and I've sent you purchase orders for the past 5 years. And every time I sent you a purchase order, you shipped the goods and filled it, or if you didn't accept it, you notified me quite promptly. Every time you didn't accept it, you notified me within 2 days. If I didn't hear from you within 2 days, every time a week later, the goods were shipped and they arrived. That would make it reasonable to believe, based upon those past practices, that if I didn't hear from you the next time within 2 days, 2 days goes by, I hear nothing from you, that you're fine. You've accepted the order. So past dealings is probably your classic example of this third one. Okay, and the last one, Steve, you will notice that I have referred to silence and inaction as just that, silence and inaction. Exercise of dominion is often lumped together under this silence and inaction category. I like to separate it because I think there's action with exercise of dominion. And this is when a offeror bundles, so to speak, their offer with property, offered property. So you're sort of getting the performance and the offer at the same time, perhaps tempting you, the offeree, to accept. And we often see this with checks. And so let's say that you and I have a dispute. Let's say that you were a builder, I'm the homeowner, you did some remodeling on my house. You think it's amazing. I don't think it's very good. I think you did a bad job. And you're demanding full payment. I'm resisting. I don't want to pay you anything. So what I do then is I send you a check and I write on that check, payment in full for work order, whatever. And I send you that check. And now students may not realize that's an offer. Offers come in different forms, in different shapes, different forms. That writing on there in full settlement on the back of a check is an offer. And I know you're going to read it because you can't negotiate the check without looking at the back. So you're going to have a duty to read because you're going to see it. And note that the duty to read rule, even if you didn't have a duty to read, if you actually read it, you can't rely upon no duty to read if you actually saw it. The no duty to read, very unusual, but even when it applies, it only applies to those who in fact didn't read and didn't know. So the person who read, I guess, is in some respects, sometimes maybe in a worse position. I recommend you read your contracts though, don't get me wrong. So you cash that check. Once you cash that check, you are exercising dominion over my property, meaning that you have engaged in an act that is inconsistent with my ownership of the property. You are getting access to those funds. It could also be I leave a book on your porch with an offer to sell it to you for $20 and you read the book. That's an exercise of dominion. You throw the book out. That is, you donate to library. That is, if you don't do anything with it, maybe you just put it in a closet. That wouldn't be. But any act which suggests you are acting like the owner of that property is what we would consider an exercise of dominion. And if you exercise dominion over offered property, that is construed as an acceptance of the offer. We don't consider it a quasi contract, a tort of conversion. It's considered acceptance of the offer, and the offer's terms, as long as they're not manifestly unreasonable, dictate the terms of this deal now. And here's the rub. The exercise of dominion operates as an acceptance of the offer, even if at the same time, Steve, you are indicating you are not accepting the offer. So let's say you cross off the settlement in full, or instead you write cashed under protest and you cash it. Doesn't matter. Your actions speak louder than your words. Even if, Steve, you call me up on the cell phone and you say, Professor Gorman, you know what? I got your check here and I reject your offer. And listen to me, as I cash your check, I'm going to keep telling you I reject. And as I'm cashing this check with the teller, I'm saying I reject, I reject, I reject. Does not matter. Your exercise of dominion trumps your contrary rejection, and you are stuck.
Well, it's pretty logical to do that because, the other party is out of the item that they were offering. And so they can't get it back. It's already used, broken, stolen, whatever it is.
Exactly right. Just don't touch it. I guess make it. I think you're a bailee at this point. I'm not a bailment expert, but I think you are what you call a bailee. So I don't know that you got to send it back necessarily, but you got to make it available for them to come get. I wouldn't use it. I wouldn't donate it. I'd touch it as little as possible. Now this is creating a problem. You talked about incentives and the wrong incentives. So this rule under the common law created a bad incentive. It created incentive for companies to mail merchandise to people and say, here's our offer. And the concern then is, they're trying to get you to use the stuff. And the concern is that once you use it, which is oftentimes pretty hard not to do. I mean, come on, Steve, let's take a little look-see, right? I mean, that's an interesting book, right? I mean, let's just, let me just flip through it a little bit here,
Or accidentally break it,
Oh, that sounds like exercising dominion. Yes.
Right. If I could see that happen if there's a piece of merchandise on your front porch and you trip over it. Now you've broken it, you've broken the flag, and you've accepted the offer.
I guess you are acting like the owner. I mean, certainly if you kick it, you're acting like on purpose, you're acting like the owner. I guess I might want to argue, wait a second. I didn't act like the owner. I'm just clumsy. But so the feds got involved. A federal statute was passed, which says that if unsolicited merchandise is mailed to you, you are free to use of it or dispose of it without liability in contract or quasi contract, to not have companies take advantage of this exercise of dominion rule. But it's not going to apply to, say, checks, which I think is where we see most often this happens, is to checks, settlement in full, and you are cashing the check. Now, whether there's consideration for a settlement is a different lecture down the road. But so this is our exercise of dominion rule. Okay, are you ready to switch to offeree?
Off to offeree.
This should not be too difficult. So we talked about at the beginning that an offer is power giving. It gives an offeree the power to form a contract. Well, not surprisingly, an offer does not grant that power to just anyone. It only grants that power to an offeree. There are some very limited exceptions dealing with option contracts, which really probably not worth us talking about. But it can only be an offeree that has the power of acceptance. So you might say, okay, big deal. And we know this is designed to ensure that the offeror only contracts with people that they intend to contract with. Way down the road, we will talk about assignment. You can actually end up having to deal with people that you never thought you would deal with, and delegation of duties. So it is interesting that once a contract forms, there's going to be a lot more leeway for that offeree to then force the poor offeror to deal with somebody that they had not intended to. But when you're talking about acceptance and that contract forming at the first instance, that is only an offeree, unless you've got something called an option contract, which we'll talk about down the road. So no big surprise there, but the only interesting thing I think here is when there is a misunderstanding as to who is an offeror, who is an offeree. This can happen. So I don't know if you remember the case of Koba versus Click Lewis, which dealt with a hole-in-one and winning a car.
So I don't remember that. Gosh, that's ringing a bell. Yeah,
taking you back.
Yes, there was some reliance or something, right, at the golf.
He walks up to the ninth hole. He's playing in a tournament, and he walks up to the ninth hole and notices a sign offering a car, which I believe the car is sitting there too. I can't remember for sure the car is there, but there's a sign that says win a particular car if you hit a hole-in-one at this ninth hole. And apparently he does. And then he demands the car. The car dealership established, and I don't think there's any doubt about this, that they had made a mistake. That sign had been put up for the prior tournament and they forgot to take it down. Whoopsie.
Whoops,
Oops a daisy.
an accidental offer.
An accidental offer. Exactly. And an accidental offeree, right? So I guess they tended to make an offer, not to this guy. They're like, no, this is people for the prize. I like to think of this as a question of offeree. I mean, that's debatable, but to me, it was kind of like, you're not an offeree. You didn't play in that last tournament. It was for those people, not for these people. And what we know is that when there is a misunderstanding, so Koba believes he's an offeree. Click Lewis didn't intend him to be an offeree. The question is, was Amos Koba's belief he was an offeree reasonable? What would the reasonable person have thought? And the court held he was an offeree because there was nothing on the sign indicating it was only for the prior tournament. The reasonable person would have believed that it was for that tournament. And so, yes, you can be an accidental offeree. And if you reasonably believe you're an offeree, you can in fact accept, but not if you know. Again, contract's not a game of gotcha. If you know they've made a mistake, you don't get to be an offeree who can accept.
Yeah, this is like a Bob Ross contract moment where you're like, happy accident, happy accident. I'm a happy accidental offeree.
And it would be great. And I guess, then you just don't feel sorry for the offeror. You're like, sorry, buddy. This is found money. And remember, this is an offer for a unilateral contract, which means, of course, if Amos Koba had not seen the sign, unfortunately for him, he could not accept because he had no knowledge of the offer, but he did have knowledge of the offer. Okay, to the terms of the offer. So here we are going to see a split between the common law and Article 2 of the Uniform Commercial Code. We talked in our very first, our groundbreaking episode. And I just meant groundbreaking. And first it was like we were breaking ground, not that it was like groundbreaking.
Did I break ground? I didn't know if you could.
We were breaking ground. Yes, we were. That's what we did. We cut the ribbon, broke ground on source of law, Article 2 versus common law. And we mentioned how it can be important to know your source of law because the rules of law could differ based upon the source. This is a big difference here. So the common law has something called the mirror image rule. Please don't confuse that with the perfect tender rule, which we'll talk about down the road. Different things. The mirror image rule provides that the offeree, in order to accept and have that be an effective acceptance, can only accept the terms of the offer. The offeree cannot attempt to accept, well, they can try, it's not going to work. If they manifest dissent and they're an offeree, but they change the substantive terms of the deal in any way, either having a different term or changing or adding a term, that is construed as a counter offer and not as an acceptance. Now, Article 2 famously changes this. Article 2 in a provision known as, I don't know, I say known as, that's what it is, 2-207 deals with something that is usually called the battle of the forms. Though when we do our 2207 lecture at some point, we'll talk about how you don't necessarily have to have two forms to have 2207 in play. But Article 2 rejects the mirror image rule. You can actually have an acceptance of an offer, have it be effective, even when the offeree changes or adds terms, but not under the common law. We have the so-called mirror image rule, meaning that the terms of the acceptance must mirror exactly the terms of the offer. And some of the things that you're going to want to look out for, the big dividing line here is between an acceptance that is conditional on additional different terms and an acceptance which, say, either makes explicit terms that were implicit, that doesn't violate the mirror image rule, or say an acceptance that is an acceptance, but asks if the offerer will do something in addition, but is accepting. I'll take your deal, but I'd like to know if you'd also be willing to throw this in additionally. That is still an acceptance, and it's asking for a modification of the deal. You might think that's sort of like a grumbling acceptance if you have a broad definition of grumbling. I'll take your deal, but I hope you'll throw something else in too. That doesn't violate the mirror image rule either. An example of the implicit term would be, let's say you hire a tutor and an offer, tutor makes an offer to you, and you say, I accept, with the understanding that you don't come to the tutoring lessons drunk. That doesn't violate the mirror image rule, because unless there's something very unusual we don't know about this tutor, that the offeree is simply making explicit a term that would have been implicit in the offer, which is that he or she will come to the tutoring sessions not being drunk. All right, any thoughts on mirror image rules, Steve? And like I said, we're going to punt on 2207. 2207 is an absolute bear. It is worthy probably of its own episode alone.
Absolutely. I think we should do a musical for 2207.
Okay, as long as I can simply I'll direct, and it'll be featuring you.
I can make a good living being paid not to sing.
Well, we can go for that too, but I guess we can't force people to watch this. Okay, the last requirement. When let's say an offeree has manifested assent, reasonable person believes they're intending to accept. They are an offeree. They've not changed the substantive terms of the deal. So far, so good. The last big requirement, and as I mentioned, we're going to talk about other things down the road, like you still have to have the power of acceptance. You couldn't have done a rejection before that. We'll talk about that down later. That's worthy of a whole podcast on its own. It is in a manner invited or required by the offer, meaning the offeror as the so-called master of the offer. It's a nice phrase to use on your contract exam. So I'm master of the offer. The offeror is the master of the offer, gets to identify the substantive terms of the deal. It kind of goes to the mirror image rule. If I'm making the offer, I pick the terms. You don't have to accept, but I get to pick the price, all the details. And if you can't change it, you can change them, but it's not a contract. But the master of the offer doctrine also permits the offeror to specify a particular way in which the offer must be accepted. And if the offeror does that, then the offeree has to comply. And if the offeree doesn't, the restatement calls it a counter offer. Most courts, I think, would say that, well, you've deviated from the terms of the acceptance. If the offeror is okay with it, they're waiving the exclusive method of acceptance. But in any event, it is not an acceptance. And I like to stick unilateral versus bilateral in here, because to me, this unilateral contract versus bilateral contract is really about the method of accepting an offer. As we talked about, an offer for a unilateral contract is when the offeror says, essentially, what I'm looking for in terms of the way you are going to accept this offer is I want you to simply perform. I'm not interested in a return commitment. I'm not interested in a return promise. For whatever reason, it's not worth it to me. I don't expect you to give it. Offers of reward is a classic example. Offer of a bilateral contract is when a reasonable person would believe that the offeror is seeking a commitment, a return promise, a promise for a promise as the method of acceptance. So if I had said to you in the Patches a Cat, Steve, if you promise to find Patches a Cat, I promise to pay you $500. It's a strange offer, to be sure. But then if you run up to me and you say, I accept or I promise, you have accepted in the required manner a return promise, and we would have a contract. But if I just say $500 if you find return Patches a Cat, no reasonable person would believe that I am seeking a return commitment from you, because I would just be weird. Who promises to find the cat? Then if you say, I promise or I accept, you are not accepting in the required manner. You are accepting in an impermissible way. And maybe it is a counteroffer. Maybe my student was quite right, but it's certainly not an acceptance. And let's say then that I have made an offer for a bilateral contract, which most offers are. Particularly if you see a writing, I slide a written contract over to you. See, this is typically an offer for a bilateral contract. If I'm sliding a written contract over to you, because I'm wanting you to sign this thing usually, and embedded in that written contract are promises. I can also prescribe an exclusive way for you to make your promise. So not only can I specify the method in terms of performance versus promise, in addition, if I do require it to be a promise, I can specify a particular method or manner of making that promise. An example would be, in order to accept this contract, you must sign on the dotted line. If you do not sign on the dotted line, you signed somewhere else, then that is not an acceptance unless it's reasonable to infer that I was just giving you what's called a suggested method of acceptance. So this is the big dividing line on this last one, is prescribed versus suggested manner. So if I say to you, Steve, to accept this offer, you should sign. I say should. It's usually too wishy-washy. That just means a reasonable person typically thinks I'm simply suggesting one way that you can accept.
Or recommended.
A recommended way, giving you the option. I'm letting you know that this is a way you can accept. I'm recommending you do that, but I'm not making it exclusive. But if I say to you, the only way you can accept this offer is by signing this contract, then that is the only way that you can accept. And if you try to accept in a different way, it doesn't mean we're not going to have a contract, because when I see you accepting a different way, the restatement considers that a counteroffer. And if I acquiesce in that and I don't speak up and I accept your performance, I manifest assent to this other method, a contract is going to be formed at that point anyway. But so this is that difference between prescribed versus suggested. You really want to look at the language that was used by the offeror. Are they using language that would lead the reasonable person to believe you've got to do it this way, or that it is only a recommended way? And let me give you, Steve, I love this case. It was a case apparently in which I send you a written contract and I say, okay, sign here and do not write below this line. You often see that, right? Don't write below this line.
Right. For office use only.
Yes. And there's all these different codes and blanks. You have no idea. You wonder like how many people are like involved in this. And the guy signs it and he writes below the line. It sounds like our flounder guy, doesn't it?
It does. I've been thinking flounder that whole time. When you all you have to do is sign here.
Yeah.
Flounder. I had that thought.
He writes, so he scribbles flounder below the line. Do not write below this line. And he writes flounder. He didn't really write flounder. He wrote something. And the question was that not an acceptance because it had been in an impermissible manner? They had said, do not. And that sounded awfully, that sounds awfully prescribed as opposed to suggested. So I do not. But what the court said, and this is very important, this kind of goes back to all this flounder business. Flounder business. That should be our podcast name. Flounder business.
It's like monkey business for a new era.
It is. Modern era. So anytime that you're interpreting language, you can't take things always so literally. Courts are not fans of taking things so literally. So yes, it said, do not write below this line. But the court said a reasonable person wouldn't think that meant that if you write below that line, that you actually were not making an effective acceptance. The court felt that a reasonable person would think that just meant, don't do that because we don't want stuff below here. But it was just more for like, we don't want extraneous writing on our documents. A reasonable person wouldn't think that the offer was actually saying, the only way to accept this offer is to sign and to not write below this line. And that result seems to make a lot of sense to me. I mean, I think like you talk about common sense, that is a very common sense interpretation of the language. And I'll give you another example, very similar. I say to you, to accept this offer, you must, let's say to accept this offer, you must deliver. Let's say you're in another town. You're in Atlanta and I'm in Orlando. To accept this offer, you must return it via overnight express mail delivery. Okay. Well, you know what? You just happen to be in Orlando at the time. And you come by and you hand deliver it to me before actually the express mail normally arrives. And the question is this an acceptance in a permissible manner? Because I said, you must, must sound serious. You must deliver it via overnight express mail. What courts are going to say probably in that situation, and this is their statement's opinion, is that a reasonable person would believe that what the offer was indicating was that you must get it to me by tomorrow. And they assumed that you'd be doing it by overnight. They weren't expecting you to show up in person. And so a reasonable person wouldn't think that that's the only way. I know they said must, but again, common sense use of language. Don't take everything so literally. Common sense interpretation of that requirement would be that it must arrive at the office by the next day around the time or at or before the time that the express mail would be delivered. And so the restatement takes the position that a common sense reading of that is acceptance in a permissible manner.
And that's so counterintuitive, when it's against the language used. And like in that way, it is kind of, it makes one think.
Indeed. So you can't, I guess if it's a multiple choice question, that'd be tough on a multiple choice question. It's like, well, I see different arguments. But if you see language like that on an essay, remember to not always take everything when you're construing language. Don't always just stop at a literal interpretation. Think to yourself, is there a common sense interpretation that is different from the way we would take this literally, and at least make an argument for one side that would benefit from that common sense interpretation of the language? Well, that is all I have for the elements of acceptance. Of course, as we know, there is more, but wait, there's more, but not on this episode. There will be, the offeree has to still have the power of acceptance, and they can lose that in numerous ways, such as rejection or counteroffer or revocation or death. That will be its own episode. And we'll also be talking about in another episode, option contracts, which restrict the ability of the offeror to revoke the offer. And a lot of events which would otherwise terminate the power of acceptance will not, if there's something called an option contract. But that is for another episode. Steve,
it's just hard to accept that another episode is in the bag.
Oh, very good. Very good. See, I'm always on alert now for your puns. So I got that. All right. Well, I hope you enjoyed it. If you've made it this far, congratulations. That is it for lesson number 5 and acceptance. Hope you had a good time listening to K-Talk.